and welcome. That's absolutely in popular demand. Because I've been told that if you don't start off our podcast with hello and welcome, it's not going to be as much fun. So, welcome everyone to our podcast. First podcast that we're having in the last 3 years, 3.5. And perhaps for the first time in the last 4.5, 5 years that I'm directly talking to my audience and that we don't have a guest, at least for now. Right? And the intention behind that is very clear, that today we're not looking at presenting any conclusions. Right? Today what I'm going to do is that I will be discussing a topic and giving you primarily the law around it. Now, some of it is going to be case law, some of it is going to be statutory provisions, regulations, and the conclusion thereafter is something that we'll always leave to you, right? And the focus of our discussion today is that of a university in Sonipat called Ashoka University, right? While a good chunk of the podcast is going to be focusing on the regulations relating to the establishment of the university, I will also be looking at some other aspects, such as why is it that founders who championed the cause of the so-called Ivy League, or once termed as an Ivy League in India, championed this cause of a great liberal arts institution, have decided to distance themselves, right? And around the same aspect, is it that Ashoka University is in any sense a liberal university, or is it that it is driven entirely by ideological dogmas and agendas? Right? As you're always aware, the agenda by the IYA focuses on as much rigor as we can. Right? For example, there are multiple other issues regarding which people have requested us to talk about in relation to Ashoka University. Right? So some of these might be allegations of tax, financial frauds, drugs on campus, so on and so forth. Right? I will not be touching a lot upon that for the simple reason that I don't have enough evidence today in my custody or possession to talk about that. That's why a good chunk of what I will be talking about is based on information which is readily available in the public domain. This is, as I said, UGC regulations, the statutory act, right? There's perhaps one clip or one screenshot from the Ashoka University website. Right? And while we proceed with this, I will always also be open to questions. If there's something which is pertinent, I will make exceptions for extremely funny ones as well, right? Because the idea is that we should also have some fun while we do this. And while the idea of the agenda has always been intelligent conversation, it has also always been interesting conversations. So we will be focusing on that as well. We're open to comments, suggestions, queries and questions. If I find something relevant towards the end of it, or towards at least when I finish the first segment around the legal aspects, we'll see if there are some relevant comments. We'll take them up. And I have to figure out the technicals of it, though I've to some extent gotten this right up until now, thanks to our great team at the IYA. But whatever is within my capacity regarding that, I will take care of. Right. So welcome everyone, and let's begin with our session today. Right. So I have to be brutally honest about this. That I also have each of these regulations, case laws separately in PDF format, and if there is a request, I will try to present it on the screen itself. Right. But so that we have a shorter discussion, so that we don't go into 4, 5, 6 hours. It's quite possible, as our lovely audience is already aware. I think I can do some technical magic here, remove the IYA logo, because the presentation looks better this way, right? We're also open to any sort of changes in terms of the format. For example, I can do something like this, and then I can do something like this. As you have already figured out, much of this is going to be just a lot of fun exercise, right? So the focus is going to be on the law for the first part of the session. And like I said, wherever there's a request from the audience, I try to provide excerpts of judgments, case law, statutory provisions. And in that regard, I've also tried to give screenshots or snippets or whatever comes out as a snipping tool in this presentation itself. Right. So I'll increase, decrease the size basis how I think it is relevant. And then accordingly, we'll see how we go about that. Also, before I move into this, many thanks to our great team for designing what is our intro video. Right. The music is obviously, it's available in public domain, but I found it all fun. And perhaps towards the end of it, when we're leaving, you will be able to hear it again. Right. So, ladies and gentlemen, this is how we go. The focus, like I said, is going to be about the creation of Ashoka University. Right. And the first question that I'm dealing with today is whether the establishment of Ashoka University was legal, or is it the case that the establishment of the university was non-est in the eyes of law. Right. Now, a disclaimer here. Right. I'm not one, and the IYE and the agenda has never been one to come up with predetermined conclusions. Right. That is not our intent here. Our intent is to present the best possible argument on both sides. So I will try to do it as much as I can. Right. Having said that, because this is more about interpretation of statutes and as well as, case law, I will provide those excerpts as and when required. I will be supplying emphasis on certain aspects, which I will embolden or italicize or underline or whatever. But the intent here will remain to give the best possible argument on the other side as well. Right? So my intent here is not to come up with a predetermined conclusion that all right, in the teeth of oryx fisheries. I think some of my colleagues are online and they're feeling very nice about that particular reference. For the uninitiated, there's a particular judgment of the Supreme Court which deals with predetermined, when there's a show cause notice given, and it shouldn't be in the nature of a predetermination. It should be to the extent that, there's a fair hearing that's given. Obviously, there's no one on the other side. It's not like there's an inquisition of any kind. And it's not like the Ashoka establishment really believes in that idea of inquisitions. But irrespective, we will give them as fair a hearing as we can. And I think that's the whole idea of the agenda in the first place, and of, at least in my opinion, liberal arts education, or at least what it's supposed to be. Right. So what about the creation of the Ashoka University? Right. So I will be dealing with the Haryana Private Universities Act, 2006. I will be dealing with the UGC Establishment and Maintenance of Standards of Private Universities Regulations. I will be then dealing with whether there is a conflict between these two and what happens when there is a conflict between such regulations under the UGC Act and the State Act. That is the Haryana Private Universities Act. Now, a couple of things to be noted here. That I'm not going to get into the UGC Act, or I'm not going to get into a lot of other regulations and generic law, which will also apply in this given case, for the simple reason, like I said, I want to keep the video short, crisp, as much as I can. Right? Only what is absolutely relevant, I have excerpted in presenting here. If there is a request, I'm sure we will be able to entertain all of those. But the generic aspects as to the UGC Act itself, its provisions, I'll maybe mention them verbally or orally, but I have not, because only with the intent of keeping it short, has been kept to be precise and only restricted to the UGC regulations, the private universities regulations, right? So I'm going to increase this a bit for our audience. This is a screenshot from, also I think I must make that fair disclosure. Everything that I'm sharing here is available in the public domain. I don't claim copyright, and the general caveats apply. This is something which is a screenshot from the Ashoka University website. Anyone can go there and check it. And this is the second FAQ after where it is located. So I will be reading this out because effectively this is the position of the university itself. And well, even if it weren't so, it's the law, right? So the question is Ashoka University a recognized university? Is it recognized by the UGC? Right. So Ashoka University was established under the Haryana Private Universities Act 2006, wide notification LEG 24 of 2024, dated May 2, 2014. We'll be coming to this just in a moment. And the reason why I've said this is because they have themselves mentioned that this is how we came into existence, that this is how the university was established, and hence I'm mentioning this. I will be going to the exact text of this in the forthcoming slides. Ashoka University is a UGC approved. There is ample law around that, but I will not be restricting myself to that. Or I will actually be restricting myself to the specific question we have. I will not be getting into the wider questions therein. In November 2014, Ashoka University was authorized to grant degrees under Section 22 of the UGC Act. All degrees conferred by Ashoka have been approved. On April 20, 2015, Ashoka University received a letter from UGC stating that its compliances have been accepted and ratified. The process of Ashoka University's UGC compliance is now complete in all respects. Now, let's get to this particular. So as we see in this particular slide, it's 2nd May 2014. This is in relation to the Haryana Private Universities Act, and the notification is legislative, I presume that's what it's supposed to mean, Leg 24 of 2014. That's what I have presented in front of you. This is a notification of the Haryana government, Law and Legislative Department. As you can see, the date is the 2nd of May 2014, and the number of the notification is LEG 24 of 2014. And I'm trying to be as transparent. I'm trying to provide as many details and trying to be actually more than transparent. I mean, all this is public domain, so there's no question of transparency per se. But we're looking at, I'm trying to be as detailed as is possible in terms of the minute details that the university itself has put out, right? Now, what does it say? So this is a notification saying that the following act of the legislature of the state of Haryana received the assent of the governor of Haryana on the 23rd of April and is hereby published for general information. Haryana Act of 21 of 14, Haryana Private Universities Amendment Act. So as Ashoka University says, and as is the case, Haryana Private Universities Act is 2006. This amendment is brought about in 2014, right? By which they say that we have been established, right? And this is the amendment to the 2006 Act, as is also seen from the preamble or the long or the short title, if I may. Long and short title both, actually. Right? So it's enacted in this particular year. This part I will be skipping through because most of these things, like I said, I've only produced the relevant excerpts. I can go through the entire act if there is a request from our audience. Right? So let's continue with this particular notification. So this notification in its clause 9 suggests or holds or observes or is, well, it's provided for. Now these are languages that, this is the kind of language the lawyers employ to say, okay, when the court says something, it holds. When the legislature says something, it provides for. In this particular case, it is a notification of the Haryana government, but it states that, as was here in the present, and this becomes relevant because this is one of the important legal submissions there. I'm not before a court, but good habits die hard. Section 9 or Regulation 9 or Notification Para 9 in the schedule to the Principal Act, which is our 2006 Act, after serial number 14 and entries there against. So the 2006 Act has a schedule, right? Which I will be coming to. I will be coming to the Principal Act as well, which has serial numbers, which are names of universities. There are 14 universities which are named therein. I will be showing all of this. And entries there against. That is, there are entries. For example, the Ashoka University, District Sonipat. That's the entry therein. And the following serial numbers and entries there again shall be added. So what is effectively happening by virtue of this 2014 notification, which has received the assent of the governor by, one would assume that obviously by approval of the Haryana legislature, these universities are added to the schedule of the Haryana Private Universities Act. Right. That is how Ashoka University comes into existence. Now, this requires a more careful study of what the Act is, right? And hence I come to the Haryana Private Universities Act 2006. So this is the schedule. This is the amendment to the schedule. And now we come to the provision itself. So the Haryana Private Universities Act has this section 6, which deals with the establishment of the university. Right? I'm narrowing this down only because we're focusing only on the establishment of the university. And in that respect, I've only excerpted this portion. If there is a requirement, like I say, we will produce the entirety of the provisions. Establishment of the university. I've highlighted some portion, but any which way we'll go over the entirety of it. 6. The government. The government here obviously means the state government. If satisfied, so there is a caveat. After considering the report submitted under subsection 2 of section 5. So this is where a report is given. Basis, section 4 that before that is again, there is a proposal, there is an intent, etc. and where you are complying with whatever other statutory norms or supposed to be the statutory norms and other regulations in terms of maintenance of the minimum standards, etc. Right? If the government is satisfied after considering the report that the sponsoring body, this is a trust, a private trust or a public trust or a society, which is the sponsoring body for the establishment of the university. This sponsoring body has complied with the provisions of 5.1, which is, as I said, they are presenting the report or the LOI there, right? And I'll come to the provisions. I'll come to 5.1 as well. It's as such. Let's assume here that the government is satisfied regarding these letters, right? That's why I'm not laying much emphasis on this. Let's assume here that the government herein is satisfied that this sponsoring body has met the conditions, whatever are to be met in terms of the report. Then the government, if satisfied, may, by an act of the state legislature. Now, it's very important here to note that a government is the state government, which is what you would call the executive per se. But then again, there you can always say that the government includes both state and the legislature and the executive. We're not getting into that. But just this phrase in the act, by an act of the state legislature, establish a private university with such name, location, jurisdiction, and with such infrastructure as may be specified in the schedule. Now, the effective purpose of this provision is that the government, when satisfied with the report, by an act of the legislature, that is, the House votes on it, establish, the government, if satisfied, may establish this. So again, the word before by here is may. So by section 5, may by an act of legislature. So it has its discretion, obviously. You can obviously force the legislature to pass an act. So it establishes a private university by virtue of an act of state legislature with name, jurisdiction. Right? I don't know how jurisdiction here is per se, but the idea here is to more satisfy the territorial jurisdiction bit, because state legislatures can only legislate in relation to universities within their territorial domain, right? And with such infrastructure as may be specified in the schedule. I'm not even going to get into these things. There is something that, for those who are interested, may look for it by themselves. Like I said, the government, if satisfied by act of so and so, establish this private university. Now, just for the sake of some clarity, like we said, there's a schedule here which is being amended. I'm going back to the amendment. The schedule is being amended, schedule to the Principal Act. Let's get to the schedule here. Obviously, something also very interesting on 49 is that the provisions of this act, that is this Haryana Private Universities Act, and the statutes, ordinances, regulations, and the rules shall have effect notwithstanding anything to the contrary contained in any other law. This is important here because it turns in it. For the time being in force, made by the state legislature relating to the universities. So there, this university act, this private university act, has an overriding effect on what? Only on other legislations made by the state government or the state legislature, Haryana legislature, relating to the universities. Now, why do I say this? Is that even if I were to interpret the commas in a manner that might suit the idea that this act overrides even central legislation or other regulations, there's obviously case law to that effect that is absolutely ultra-vires the constitution, and more so, as Professor Yashpal's judgment, which we will be discussing, is a fraud on the constitution. Right? But let's give this the most basic interpretation to not give away its constitutionality, that it is other state legislations which will be subject to this particular act. And then we move to the schedule. We have section 6 in relation to the schedule, which I have shared with you already. And then we move to the schedule. So as you say, there's one university which is already established at that time or whatever. I'm not going over all of the names. That's irrelevant to our larger question. So we are at, and we have serial number 15. As we saw, after 14, these three are to be introduced. Section 50, serial number 15, Ashoka University says District Sonipat. Now, what's important right at the bottom is amended by the Haryana Act number 21 of 2014. Right? This is the act that I showed earlier. Let's see if we can change this about a bit. Right? Yes, that seems fine. Or if it's actually the text is too small, then we actually move back to that one. Amended by the Haryana Act number 21 of 2014, assented to by the governor on 23rd April, as was mentioned there, and published in the Haryana Gazette on the 2nd of May 2014. So this is effectively the same thing as had been discussed at an earlier stage. I have only given the text which is prevalent here as well. Right. Now, as we look at this, this is the state legislative framework for establishing the university. Right. So by this, there should be some sanction in the eyes of the law for this particular university to be having been established legally. Right. In that respect, that was a very interesting point. Right. Why was there a need for this Haryana Private Universities Act? That gets us to the next question. And the need for it arises from a three-judge bench judgment of the Honorable Supreme Court in Professor Yashpal's case. Right. So we can, in fact, I think I can also share Professor Yashpal's case. Right. So this is the judgment. I don't know how much larger I can make this. Right. So we can go over some of the specifics. Right. I'm not going to go through the entirety of the 50 odd pages of this judgment. And I don't know to what extent it's very relevant, because I don't think there's any point, because the text here is any which way small. Let me see if I can make this larger. Yes, we're getting a full scale, but it's not very high text quality in terms of the size is too small. So we'll get back to this one, and I'll just go over the specific portions of what the judgment was discussing. Right. So the question before us here today is, what is the need for this Haryana Private Universities Act? Right. Then why does there have to be an act of the state legislature? So the question being considered in Professor Yashpal's judgment was to do with the fact as to whether the executive or the state executive could, by virtue of an act of the executive, by adding a mere notification, publishing a mere notification, lead to the creation of the institution which you call a university. Right? A university which is permitted, which has the legal sanction to provide or grant the conferment of a degree. Right. So in that particular case, the state therein had passed a legislature, or it was specifically an adhiniyam, basis which they said, all right, these all universities will be, whenever the state government may so desire, it shall establish universities by publishing it in the schedule, or publishing it in the particular notification and adding to that schedule. So there's hundreds of judgments which are added, hundreds of universities which are added just by virtue of adding them through the notification. Now, this process came to be challenged ultimately before the Supreme Court. And like I said, the judgment's right here. The citation has been provided. So this is all in the public domain. Anyone who wishes to read the entirety of it can obviously go back to it. I'm just giving a brief overview, because there's a lot of other aspects to the judgment as well, because it deals with the constitutionality, and that is the primary question that we will be discussing. But I'm only referring to this for the moment as to what is the need for the act. So the Supreme Court holds that it is impermissible, it is illegal, and it is actually a fraud on the Constitution that a state legislature suggests that it can create, or a state government suggests that it can create a university merely by publication of a notification. Why? What is the basis behind this? I'm moving beyond the law. I'm moving beyond, first principles of polity. What is the basis for suggesting that state governments cannot give out degrees for the asking or cannot create universities for the asking by coming up with a notification? The first reason behind this, and the reference here is made to, again, Section 22 of the UGC Act says that, all right, this is how degrees are to be conferred. Section 3 says, okay, how are universities to be created? Right, so this judgment deals with all that. Section 3 of the UGC Act 1956 effectively says that, listen, either the university is to be created by an act of the parliament or by legislature of the state, or there are certain institutions of excellence. I think that's the path, AIMS, IIT, etc. They go into, that's why an IIM gives a postgraduate diploma as opposed to, a degree. It's a diploma that you get there because this is the statutory provision that they're supposed to meet. And then there's obviously the concept of deemed to be universities, right? So that's why till date there are multiple universities, and you can sort of go on and check this because I don't want to name anyone by saying, oh, this is only deemed to be, it's not university. The universities are required to, by matter of this statutory provision, say that they are deemed to be universities. The purpose behind that is simple, that you still make a distinction between what a university is and what a deemed to be university is. That, okay, someone at an earlier stage was a college, has done well, was affiliated to another university, and then they're given that status. So again, they're still empowered to give degrees. But then again, there is a distinction that is maintained that just because you are conferred the right to say that you are a deemed to be university, that doesn't mean that you can say you're university simpliciter. So that distinction is there. Why? Because, and the whole premise behind all of this is that the conferment of a degree is a sovereign function, right? Why? Why is it a sovereign function? Right? Because you're giving someone education. Right? In the old days, right? I'm talking about some century, millennia, whenever universities came about, right? It's about at least 900, 800 odd years that we've been having universities. It was mostly, charter of the king, right? There were certain clergymen involved in the creation of universities. They petitioned the king, and then they said, all right, you would be able to grant this degree. By virtue of what? By a decree by the king, effectively, right? Now, I don't want to get into the specifics and technicalities of how universities per se were, envisaged some 1,000 odd years ago. But the idea is that this is not something that is a mere delegated function. It is a sovereign function. And hence it is only by creation through an act of parliament, that is by an act of parliament, and this becomes relevant. And that is why Professor Yashpal's judgment becomes relevant here, is that it is by creation of this act, that is the act should say, all right, this university comes into existence. Right? Hence the need for this. What had happened there was that by notification, universities were being added, and eventually the Supreme Court held that nothing doing, boss. You cannot add universities this way. You need an act of parliament or legislature. And even in that respect, what the court had specifically held was that UGC regulations, because the UGC regulations had mandated this aspect as well, additionally. And we will be discussing that aspect as to, okay, if there is a clash between a UGC regulation that says something, created by a central body and a legislative body of the state, which prevails. Now, one may say, oh, that's a legislative, you're talking about, UGC being a body which is executive or regulatory in nature, as opposed to, a state legislature, which is supposed to be more sovereign than that. Right? But the points that we'll be dealing with in this ample settled law in this regard is that simply a regulation where validly made becomes a part of the act. So where the UGC regulation has been validly made, it becomes a part of the UGC Act, which is a central legislation. Now, with respect to this, we'll move into what is one of the most beautiful constitutional, not just from an academic point of view, just like I think we lawyers quite enjoy the idea of interpretation of the 7th schedule. Now, for those who are not familiar with it, this deals with our lists are lists as to which legislature can deal with a particular subject when it is legislating. So this is where our federalism question comes about. Right? So list 1 deals with the union, list 2 deals with the states, and list 3 deals with concurrent. So we'll be dealing with entry 66 there, we'll be dealing with entry 32, 25, we'll be dealing with all of that. But we'll come to that when we move to that question. But here, the only reference to Professor Yashpal at this point is that you need an act because you cannot confer it merely by executive fiat. So in this particular case, 100 odd universities, by one stroke of the pen of the Honorable Supreme Court of India, held to be absolutely void. Right? They were shut down because the creation itself was not legal. Right? If there are queries, we will obviously make it a point to bring up the judgment per se, depending on whatever question is. Yeah, so now we get to the particular reference to the private universities regulations. Now, what I've established earlier is that, all right, there is a state legislature, right? A state legislature which has provided for the establishment of this university by including it via amendments to its schedule. Right? But there is also at the same time, and hence the question as to, does this act suffice? So in this regard, we make reference to, as I said, the UGC private universities regulations. Right? Establishment of and maintenance of standards in private universities regulation 2003. Now, why this becomes relevant, and as I said, entry 66, right? I have not produced this because I thought it's more generic and this is not something that requires me to, preach on. I mean, I hope this is not preachy, but list 1, which is the union list of the Schedule 7 of our Constitution, this becomes extremely relevant. Entry 66 is coordination and determination of standards in institutions for higher education or research and scientific and technical institutions. So this is the union list, right? So that's one element as to how this comes about and becomes relevant. Right? So let's look at these regulations which are supposed to govern. Right? So I'm going to make this slightly larger. Right? I'm only on the notification part that, this has been published in the Gazette. There's nothing else which is per se important at this particular screen. The only reason I wanted to bring about is that the ministry has specifically mentioned, and this obviously the date of this post, which is in relation to a parliamentary question, is much later. But just the first paragraph, it specifically says that in order to, so it says obviously that the state private universities are established by acts of their state legislations and they're regulated by these acts. However, in order to ensure transparency, quality, and standard of education in these state private universities, which takes us back to entry 66, the UGC has notified these regulations. As far as private deemed to be universities are concerned, they have separate universities. Like I said, there's a distinction between a private university and a private deemed to be university. We're not dealing with a deemed to be university, hence we are restricting to the university alone. Right now, we get to these particular, the 2003 regulations. So let's, try to, if it's too small, I think I can always increase this one. So the first question that arises at this stage, I think I've asked too many of those, is whether these UGC regulations apply to Ashoka University. Right? So 1, 2, I'm going to read out here. They shall apply to every private university established by or incorporated under a state act before or after the commencement of these regulations. Now, these regulations 2003, before or after, so it applies at any point whatsoever, and it applies to every private university established by or incorporated under. Now, what's the difference here? By is when the legislature says, boss, I will pass an Ashoka University Act. Or incorporated under a state act is also, the same point that we get back to Professor Yashpal's judgment, is that you're brought in through that notification, that annexure, that schedule, the schedule which is appended to the act. It's obvious in this particular case, the argument will be that, listen, this is not a notification, this is an amendment of the act brought in by the state legislature. Right? So that's the argument that will be given by the other side, or to suggest that, listen, this is established by the act itself. All right, let's assume it either which way. But the idea is that these regulations apply to every private university. Right? And then we have 2.1 right at the bottom. It says that private university means a university established under a state or a central act by a sponsoring body, a society registered under so-and-so, or any other corresponding law, which can be private trust, the state, or a company registered under Section 25 of the Old Companies Act. So this makes it clear that the particular regulations in question are applicable to Ashoka University, right, for everything that's been following up until now. But let's therefore get to the effective provisions of this regulation. Right. So the question that we're dealing with is whether the creation of Ashoka University was legal and whether the Haryana Private Universities Act in this respect by itself suffices. So I'm on the same regulation as I brought about earlier. These are the same regulations. I'm reading 3.1 as is on the screen. Let's see if I can increase this even further so that it's better for those who are trying to read it. Right? I made it much larger. So it says establishment and recognition of private universities. Each private university shall be established by a separate state act. Let's repeat that for a moment, because I think something might turn on this. Each private university shall be established by a separate state act and shall conform to the relevant provisions of the UGC Act as amended from time to time. The second part of the provision, we're not concerned here. Let's assume that the university complies with all of these provisions of the UGC Act or all other provisions of the UGC Act, if you may call it that way. What is this provision otherwise? What should be the effect of this provision? It says that every private university, which Ashoka University is included in, shall be established by a separate state act. Now, this is also the same principle that is discussed in Professor Yashpal's case. Right? That you cannot say, okay, take a bulk order and say, listen, we will make everything a university by way of a notification. What is required, because as a sovereign function, Section 3 read with Section 22 of the UGC Act, what is required to be done is for the university to be established by a separate state act, because you're giving it sovereign function to give out degrees. Hence, the purpose of this particular provision. And like I said, entry 66, list 1, schedule 7 of the Constitution should suggest that this is well within the powers of a union or a central regulator. But that's also besides the point. Right? What if there is a conflict? So on one end, we see that the State Act is something which is created by the state legislature. And at the same time, these regulations exist. So what should cover the field? It is not like the State Act, that is the Haryana Private Universities Act, creates every private university as by a separate act. That's not the case. So that particular enactment is in the teeth, that state enactment is in the teeth of these UGC central regulations. So if there is indeed a conflict, what should prevail? That's the next logical legal question. I'm getting very funny comments as well, but for the moment we will not. Vijay, so Vijay is a very dear friend from college, great finance whiz kid. They have a great gaming company, and I'm not being paid to advertise this. He's a dear friend, and he's come up with very funny comments, but for the time being, for those on YouTube may refer to it by themselves. Nonetheless, I said I would make it a point to at least refer to what he is saying. Right? I think there's a T missing there very clearly, but the larger point is that what happens if there is a conflict between these UGC regulations and this Haryana Private Universities Act. So what are we looking at? We're looking at UGC regulations made by a central regulator and an act of the legislature. Right. So there are these judgments of the Honorable Supreme Court of India that I'm referring to, which deal with very similar or the same questions, apart from Professor Yashpal's judgment, which is something that we mentioned earlier. The first one is Dr. Preeti Srivastav's case, which is a constitution bench, which is 5 judges. And then you have Mahesh Yogi Vedic Vishwavidyalaya and you have Parsvana Charitable Trust. This is dealing with conflict of UGC regulations and Haryana private universities or private acts of state legislatures. And why do I say this? So there are two aspects to it. One is that obviously our constitutional framework says that all right, state acts wherever there is the domain and the jurisdiction only of the state governments, their acts will prevail. Where the union has come up with an act and the state has passed an act and the union has passed an act again in relation to the third list, that is the concurrent, where both of them can pass laws, then the state act will be superseded by the union act, the central act of parliament, because they've come up with that act thereafter. Right? And then thirdly, where there is a union act, as the UGC Act, and then there is the state's power to create universities, which is well within their powers. What happens? So before I enter into this, just one relevant aspect with respect to list 3, the concurrent list, where both the union and the state can pass legislation. Entry 25 therein, which is brought in by the 1977 amendment or the 42nd amendment, right? A mini constitution, as it was called then, says education. So this is the concurrent power also of the states. Education, including technical education, medicinal education, and universities, subject to the provisions under section 63, 64, 65, and 66 of the list 1. That is, as I said, the maintenance of the standards or coordination and determination of standards for institutions of higher education. Right. So this is effectively suggesting that, and in that reference, reference may be made to the Gujarat University case. I should have the citation because this is a fun aspect. It's AIR 1963 SC 703, which dealt with this question for the first time. So to be more specific, it's Gujarat University versus Krishna Ranganathan Mudholkar, right, which deals with this question that we're still on. What happens? State can make that. So I'm purely on the constitutional aspects of this. Right? State can make an act. Then basis entry 25 itself, it is subject to these standards established by the center, which means, and which is what the judgment in this case also says, and all thousands of case laws thereafter, is that the central standard maintenance of those minimum standards, even if by regulations, will prevail over the state act. Right, so that gets us to the first judgment. The first, I think I've accepted that, is the judgment in Dr. Preeti Srivastav's case. Right, let me increase the font here so that people are better able to read it. Right, I feel very sad for those who are doing this by virtue of their phones. But let's see if we can make this larger so that I hide my face. I think that seems reasonably large. Right. I think we're covering more of the entirety of the screen is there, and I'm absolutely in a small space, so that's the best way that we should have it. So what is Dr. Preeti Srivastav's case suggesting? Right. So just to be for my lawyer friends and even for the non-lawyer friends who take some interest in this, right? So this judgment is by the Constitution bench. There is 5 judges. This particular judgment is the majority opinion. So thereafter there is also a dissent, right? But that's not what we are referring to, obviously, because this is what the law is. And in that regard, the majority opinion here is by Honorable Ms. Justice Sujata Manohar. Right? This is not something that's per se required, but I'm only sharing it for those who are, interested to cross-reference, to check whether what I'm suggesting is factually and legally correct. So I share my sources. We try to be as accurate and as transparent, and that is the agenda of the agenda. And that's not the end of the agenda. It is the agenda. Right. What would be a fun podcast if you don't even make some wisecracks and dad jokes? Yes, so coming back to the judgment. So what is held here? This is in the relation of regulations pertaining to medical education. Right. So I'm going to read it out entirely. I will lay emphasis on the part that I have laid emphasis on. Supreme Court in Preeti Srivastav's case says, 52, Mr. Salve, learned counsel appearing for the Medical Council of India, has therefore rightly submitted that under the Indian Medical Council Act of 56, the Indian Medical Council is empowered, like again, this is not the legislature by itself, this is a regulatory body. setting standards, is empowered to prescribe, inter alia, amongst others, standards of postgraduate medical education in the exercise of its powers under Section 20, read with Section 33 of the Indian Medical Council, has framed regulations which govern postgraduate medical education. Now, obviously, that part is not as such in sort of applicable here. This is not medical council. This is not the medical education, Ashoka University, and I'll come to that, how the branding is changing. But Ashoka University has not intended or has not marketed itself as a technical education center or university granting degrees in. It was set up as a liberal arts university. Full stop. But we will get to that when we move to the later parts of this discussion. We will absolutely get to that. But now coming to the more relevant part as to what is applicable here when there's a conflict. These regulations, therefore, are binding, and the states cannot, in the exercise of power under entry 25 of list 3, which is what I read out earlier, make rules and regulations which are in conflict with or adversely impinge upon the regulations framed by the MCI for postgraduate medical education. Since the standards laid down are in the exercise of the power conferred under entry 66 of the list 1, the exercise of that power is exclusively within the domain of the union government. The power of the states under entry 25 of list 3 is subject to entry 66 of list 1. Now that gets us to the main point. That all right, where there is a conflict, even when there are regulations made, because it's about laying down some standards, much like the private universities' establishment and maintenance of standards, as is the 2003 private universities regulation. So entry 66, because it prevails over list 3, entry 25. Therefore, the regulations of the central or the union regulator will prevail. I think I'm laboring the point too much here. Nonetheless, let's move to the next one, which is also similar in that sense, but why I'm now bringing to this, because this specifically deals with the UGC regulations. They're not, I think, the private university regulations per se here, but let's go over this and let's see what we come about. I think we also see the reference to our beautiful Gujarat University versus Krishna Mudulkar right at the end. So this is Maharishi Mahesh Yogi Vedic Vishwavidyalaya versus State of Madhya Pradesh. Very interesting. I think many of these judgments are State of Madhya Pradesh. So I have no particular reason as such, but that's all right. Just easy to remember, right? Because I can go back to Justice, it's Professor Yashpal's judgment. I'm not trying to show off anything here, but I think it should be 2005 SCC 420. We can check on that, or maybe you can look up the law by yourself and see if I'm correct. Right. So now we move to Maharishi Mahesh Yogi Vedic Vishwavidyalaya, which is apart from the submission on Section 4, learned counsel, while attacking the amendment made by including proviso so and so, contended that as far as the introduction of various courses as well as opening of centers are concerned, that's the topic in relation to which the regulations were, they are exclusively governed by the UGC regulations, which was framed under the provisions of the UGC Act, and therefore the introduction of the said proviso was directly in conflict with the occupied field by the UGC Act, and consequently ultra vires of the constitutional provisions. Ultra vires means beyond the power, right? For our non-law friends, beyond the power. It's also absolutely beyond the, I just like to use this phrase very often, jurisdiction. Right? Beyond the jurisdiction of the state legislature. The learned counsel relied upon Professor Yashpal, something, but this shouldn't be, okay, state of TN versus Adhinayam is separate. So Professor Yashpal is one judgment which we covered. State of Tamil Nadu versus Adhinayam Education and Research Institution, which is also another judgment, similar line. And Gujarat University, Mudholkar, which is also the same line. Reference is also made to Section 12 of the UGC Act in support of the said submission. Right. Now, very well, this is, now that I read it, I think it's more in the sense of a submission. We can disregard it at least for the time being. But if we go down further here, you get the same conclusion. and wherever required, we bring in the judgment. Right? So here we get to the conclusion. So it's not like I've only given a submission here. This is the submission which goes on to be accepted. Right? So let's get to 110 and 111 of the same judgment, where it said that in the light of the said reasoning, I've skipped through all of that. You have the paras, you have the citation, you can take it up. It will also have to be held that running of centers by the university would fall within the exclusive realm of List 1 Entry 66, which would in turn be governed by Section 12 of the UGC Act, and consequently, the state government to that extent should be held to lack the necessary legislative competence, ultra vires, to meddle with such centers set up by the appellate university. In that case, the state had placed restrictions, etc. We therefore hold the restrictions by virtue of Section 4. We therefore hold that the entire proviso to Section 4, Roman 1, has to be held to be ultra vires. This is an act of the state legislature in the teeth of the UGC regulations. The entire proviso has to be held to be ultra vires, that is beyond the competence of the state legislature. The contention of the learned counsel for the appellant therefore merits acceptance, and the contention to the contrary made by the learned counsel for the state of MP stands rejected. Now that gets us to the broad point that I've been on. What happens when there's UGC regulations on one end and then there is state legislation on the other? UGC regulations prevail over the state legislation. In this case, there's also Parsvanath Charitable Trust. Similar lines, because we're nearing an hour. My idea was to do this for about 2, but let's try to shorten this. Right? Oh yes, absolutely. I think it's a very interesting point that I got in here. Consequently being the important, but we'll get there. I think we're not bringing up comments right away. And I think I don't have a name on that comment, though I know who that might be, but we'll bring that up later. Right? Consequently is always because that goes. In that respect, once I complete this, I'll come to one particular maxim. Satya's been asking me for too long that, I've used Duralex, Sedlex for too long, so please give me a good new maxim. There's a couple of books there, but we'll give one when we get to the end of this portion. The Honorable Supreme Court in Parsvanath's case says what? Also dealing with, fields of technical statutes like the present one, as well as the NCT Act, IMC fall within the ambit of canon of law. We're looking at a central act here, right? AICTE, supposed to be capital, but I think the original print, which comes when you take a smart copy, it becomes this way, is the authority constituted under the Central Act with the responsibility of maintaining operating standards and judging the infrastructure facilities available for so and so, imparting professional education. It shall take precedence over the opinion of the state and as well as that of the university. This is the pedestal on which union standards have been placed. Everything else becomes an opinion of the state. But that particular case, we're not specifically dealing with, or we're not looking at here state legislation. But nonetheless, whatever be the domain of the state, the standard setting and maintenance of such standards have to prevail over the particular state opinion, law, whatever that might be. The department concerned of the state and the affiliating university have a role to play, but it is limited in its application. I think I'm going to make this a bit larger. Yes. Is limited in its application. They cannot lay down any guidelines or policies in conflict with the central statute or the standards laid down by the central body, which means that it doesn't even have to be a central act. Even the standards are lower than regulations even. Let's assume the regulations are standards. So nothing can be in the conflict with that standard laid down by the central body, which in this case is the UGC. The state can frame its policies, But such policy again has to be in conformity with the direction, not even regulation, direction issued by the central body. Though there is no conflict in this case, yet it needs to be said and clarified. The grant of the approval by the state and affiliation of the university has increased stakes on. So again, that becomes less relevant in the particular case that we are handling. But the broader point here is that this is the standard on which entry 66 of list 1 of schedule 7 of the constitution is. And this is the standard on which UGC regulations have been placed, even in light of state legislation. That this is how they will override the other. Well, I think I'm nearing the point of the law, so I need to at least, I've covered this part. Let's see if we can. I think this part we've covered, so I'm going to keep this small before I move to the next part. 1 hour for the law has been very reasonable. Again, I've not dwelled into a lot of other things. Where there are requests, we obviously bring in provisions, case law, etc. But what's the broader point here? Let's go back to the broader provisions that we're dealing with. So we have here this provision. Every university has to be, each private university shall, there's mandatory words and girls, shall be established by a separate state act. This is UGC regulations. We've seen UGC regulations are supposed to prevail over all state legislation, everything else. And the university is to conform to whatever standards in the UGC Act. So this is the standard set by the UGC that, boss, you have to create a university by virtue of the separate state act. This goes back to Professor Yashpal. And then this gets us here. That is, it applies, but then it takes us back to this act. That is this a separate act? Is this a separate act? The answer to that is plain no. And before I get to the best argument on the other side, I think what is also relevant here is that this is not by virtue of a notification. So this is not the best argument. I'm sure we can have better arguments on the other side. But this is not by virtue of a notification, but it still remains. And I'm going to, qualify the argument on the other side once again. Our synthesis, how do you read synthesis? By thesis and antithesis and so on and so forth. So much for critical education or critical thinking, which we'll get to soon. But the point with respect to that is that it's still being added by virtue of a schedule. Let's assume schedule is also an act or appended to the act, is part of the act. I'm sure we can argue that. But is this a separate act for the establishment of the university as is mandated by the UGC regulation 3.1, 2003 private regulation? Private regulations, UGC private regulations, private university regulations. The answer is a plain and simple no. Right. Now let's take the best argument on the side of Ashoka University. To defend its creation, right? Like I said, we spend, days arguing jurisdiction and then we get to the merits much later, which is not something that I've been dealing with right away. Right. But what am I on here? What is the best possible argument that the university will come up with to defend this? And I think to some extent it's rooted in that same Professor Yashpal judgment, which you can borrow from the other side, is that there may not be one separate special act, there can be a compendious act. That is this Haryana Private University Act, a compendious act for the creation of the university. That is, multiple universities being so-called created. That's the point. That's the argument that the other side will make on this one. And in relation to that, my response would be, can that be done by virtue of adding numbers and names to an annexure or a schedule? I would humbly submit no. Because the purport of 3.1 of the regulation is very clear. Like I said, that summation, there are 54, 55, 56 onwards in Professor Yashpal's case. Like I said, 2005, 5 SEC 420. That comes from there. The Supreme Court will say, no, you don't need a separate act. You can do with a compendious act. Even if I would accept that submission entirely, I would say that even that has not been done. Obviously, it's a very interesting question on stopping or mushrooming of private universities which are charging exorbitant fee, but we'll get to that. TMA Pi, Inamdar, St. Xavier's, Islamic Academy, 11, 7, 5, kept on having constitution benches. There's a question by Mr. Dutt. So we'll get to that. We'll get to that. But yeah, that's primarily, before we get to these questions, very interesting question by Mr. Dutt. I'll get that on the screen soon. But the broader point that's been made here, and as is evident from these provisions, these case laws, is that the establishment of the university without there being a separate state act for such private university would be non-est in the eyes of law. That is the very foundation, the very basis upon which this university has been established by virtue of this schedule is non-est. The foundation itself is not there, hence the superstructure or the structure any which way collapses. Like I promised, the principle applicable, and very dear friends who enjoy this one as much as I do, is called Sublato Fundamento Cadit Opus. You take that down again. Sublato Fundamento Cadit Opus. Principally, which means that where the foundation is destroyed, the structure collapses. And in this particular case as well, because this has not been complied with, because there's no separate state act, and you're introducing universities by adding serial numbers, it is ultra virus and non-est. Therefore, my take on this is that the creation of Ashoka University is ultra virus, the Constitution of India, settled law by the Supreme Court, and the statutory regulations that govern the field. Any which way, I'm no court of law. This is not a question before a court of law, at least at this stage. And hence, I mean, if it was so, then there would be a different question. But that's not the case. But my idea was to present this exposition of the law, to come up with these explanations as to why, listen, this university and the creation of this university could be illegal. But like I said, there's an argument on their side, composite. I'm saying, listen, not necessarily that. Why? Because you're just introducing, amending the schedule, adding a name, adding a number, and that is not even the domain of Section 6. Because if you go back to Section 6 once, the government by an act of state legislature, this was brought in to meet Professor Yashpal standards, establish a private university with such a name, location, jurisdiction, and with such infrastructure as may be specified in the schedule. I'm sure we'll find some infrastructure and other things being added to the schedule. But the way we saw it, which is right here, there doesn't seem to be any. So even on a plain reading of Section 6, difficult to sustain this. Right. Now, we have a very interesting question. I'm going to try to show this by Mr. Yash Dutt. Right. Mr. Sarwal, how to stop mushrooming of private universities which are charging exorbitant fees from students and employ professors with zero to no scholarship or merit. There's ample settled law on that. Right? Like I said, TMA Pi, which deals with the scheme which comes about in Unni Krishnan, where the Supreme Court lays down the scheme as to, fees being lower and there being the setup of the committees across, and that scheme is thereafter overruled by the Honorable Supreme Court, saying that, listen, Article 19, there can be an element of gaining fees or, raising money by setting up a university, because the university needs money to run. You're absolutely right. Your point, Yash, is that it should be with respect to, what do you do with exorbitant fees where professors have no scholarship on merit. There are standards. There are standards everywhere. I think there is an ombudsman or ombudsperson for Ashoka University as well. My understanding, basis what the website shows, is that it's just as local. But that's not what we are looking at here per se. Right? There's ample reliefs that can be sought, complaints and representations that can be filed with the UGC or other regulatory bodies where you deal with technical education, right? Pharmacy, AICT, technical education unit, architecture council therein. So all of those aspects are there. Those representations can be done. But at the same time, Supreme Court also holds this, and from an economic point of view, from an economic policy point of view, from wanting the country to go ahead, mushrooming is a problem, as the Supreme Court also holds. Right? You can't have universities coming up without there being any substance or rigor involved. That's absolutely correct. Private universities per se is not a problem. You can also raise funds. That's not a problem. The Supreme Court holds that. Otherwise, university कैसे चलेगी? पैसा कैसे होगा? पैसा नहीं है. पैसा नहीं होगा तो इंफ्रास्ट्रक्चर नहीं होगा. इंफ्रास्ट्रक्चर नहीं होगा तो बच्चे नहीं आएंगे. वो पढ़ेंगे नहीं. फैकल्टी के पैसे कैसे दोगे? But what problem being highlighted here is that there is no intent, right? Which is not something that I'm looking at per se or examining. But it's a very relevant concern. Supreme Court also held it. And I think Mr. Dutt is asking a question only to make sure that he also has the answer to it, which is that it's expounded in Devinder Pal Singh Bhullar. There you go. He has always had that answer in that sense. Mushrooming has been dealt therein. But then again, like I said, we're not entirely saying that, Ashoka is part of mushrooming of private universities. We don't have any problem with suggesting, private capital mustn't be employed. Supreme Court has held again. You need to raise some amount of fees. It mustn't be exorbitant. That's absolutely correct. It cannot be exorbitant in that sense that it cannot be permitted to be expropriatory, or it cannot be, okay, listen, I'm going to take as much as I can. That part shouldn't be there. And so there is an element in the act of the state as well which deals with, if I were to deal with, the financial aspects, which I said I'm not dealing with extensively. I'm not dealing with financial or tax evasion, etc. But I can still deal with how does financial aid play in, the functioning of the university, and to what extent is it that such an act is, by act here I mean the one with a small a, that is an act of running this university, whether or not it is philanthropic in the first place. Right? So that element, like I said, I'm not going into that because we were already touching in R right now. But at the same time, if there are requests, if there are suggestions, if there is some public demand on this, we'll definitely be willing to also discussing that. Be open to discussing that with financial aspect as to how money moves in this regard. Right? That is, like I said, not dealing with tax evasion, not dealing with financial frauds. That is only with respect to whether something is a philanthropic institution or not. So we can look at that at a later stage. Some people are looking at appointing special officers. But there's an interesting question here. All right, so very interesting question. I think that's extremely interesting by Abir. The question is to give due legal sanction to a new university. Can the legislature amend the existing act with the subsequent name? So I don't know what the with subsequent name here per se mean, but I think his idea is that you bring in, is it permissible for the university to be created once again by virtue of there being a special act separately for the university? I presume that is the one way. Right? Can the legislature amend the existing act? They've been amending the existing act. That's the whole idea. They've been amending the existing act, but that is still in the teeth of Regulation 3.1 of it. Right? 3.1 mandates that there has to be a separate state act. So I think I'm unable to get the last part of it, but the idea here is that, okay, you bring in a new act for every university that exists. That's the one way to comply with this. Right? So that is one element that we've dealt with. That is the question of law relating to the establishment of Ashoka University. What we've tried to establish and substantiate upon is that there is no legal basis, right, for the establishment of the university. Like I said, I've tried to give arguments on the other side as well. I said, okay, they'll say, compendious act, this, that. Also trying to trace it back to Professor Yashpal. That is there. I'm just giving the best possible argument on the other side. And that should be done. Like I said, our best idea is not to come up with one side or not to come up with a predetermined truth, but to come up with a particular truth which is in light of the best arguments on both sides. But like I said, I think it's a schedule. You're adding one line. You're still not even in compliance with Section 6 per se. And like I said, I'm not dealing with other provisions of the UGC Act. I'm not dealing with thousands of other Supreme Court judgments. But I'm certainly dealing with just this one particular aspect, which in my understanding suffices to answer the question that we have here today. Right. Now we move to the next aspect. Right. I'm going to be brief about this for the simple reason that there ought to be some element of I don't have as much information about this. Right? So I don't have as much information, or I don't have evidence. I have ample information, mind you. I don't have sufficient evidence to get into, whether Ashoka is a far left institution, whether there is, drugs going on in campus, whether there is, financial fraud, tax evasion. I'm not going to comment on any of it. I'm not going to talk about professors making comments on the merits of the free speech of those comments. Right? Whether or not Ashoka University believes in free speech, whether or not Ashoka University's professors believe in free speech, is not the subject matter of this discussion today. If there are requests, obviously we'll deal with those at a later stage. But the broader point with respect to that is that those aspects which I don't have sufficient documentary evidence for, I will not be touching upon as such. Right? But at the same time, in my personal opinion, is to be taken in this regard. With respect to purely private education, it is the need of the hour in the country. If you are going to build, and I'm not saying Ashoka University is a left-wing, godless communist institution, not at all. I'm assuming that Ashoka University isn't that, right? But even if it were, even if that were the intent of these founders, might as well have private money being blown up. Why should the taxpayer, why should the exchequer pay the brunt for something like that? The idea is that, all right, these are public resources, they should be utilized for the fulfillment of whatever other goals of the development of the country. If ultimately a university is nothing but an ideological breeding ground on any side of the political aisle, better that it be done through private money. Better that it be done without wasting state resources. It's also not my case that Ashoka University or anyone else in Rajiv Gandhi Education University or any other university under so-called purportedly made under the Haryana Private Universities Act has never gotten any state benefit. Right? We don't know how the land is given. We don't know from where the land is, how it's purchased. I'm not even getting into all of that because, like I said, that's not the exercise that we're doing here today. But is it not better that private money is spent on it? Sure, there's more scope for misuse, etc. Be that as it may, ultimately it is the parents, it is the students, it is the faculty, it is the society at large. It is, if I were to say, in the free market sense, and there's a choice of going to that university. And the market should decide it. Where there's free ideas, exchange. People say, okay, this is why it's good, this is why it's bad. And the market decided. And let people spend their money to create universities, so-called thousands of crores. If you go back to the website of the university, there are foreign institutions. There are able professionals who've been listed as founders and sponsors. Maybe they put in money, maybe they're given other services. So that element should always be there. And that's also something the Supreme Court recognizes in 3 large judgments. Like I said, TMA, PI, so on and so forth. But that gets us to something different. Like I said, I've assumed all of that in Ashoka's favor. And I've said, still, it's better that you spend your private money. And I will deal with how the founders are distancing themselves as well. Right? Is Ashoka truly liberal? By liberal, I mean the classical liberal sense. मैं जो कानून के तहत, विधि के तहत करना चाहता हूं, मैं कर सकता हूं. ना आप मेरे काम में दखलंदाजी देंगे, ना मैं आपके काम में दखलंदाजी दूंगा. क्लासिकल लिबरल का ये मतलब होता है कि सरकार आपके बिजनेस को बेफालतू में टेक ओवर नहीं करेगी. आपको बोलने की आजादी है, आपको धंधा करने की आजादी है, आपको चलने फिरने की आजादी है. These are liberties. एसोसिएशन बनाने की आजादी है, अपने रिलीजन को फॉलो करने की, जो रिलीजन आपको सही लगे, एक मर्यादा के अंदर रहते हुए, किसी की जान, किसी की हेल्थ, इन चीजों को अफेक्ट ना करते हुए उस रिलीजन को फॉलो करने की आजादी है. तो ये आजादियां अगर आप एक्सेप्ट करते हैं, जो कि हमारे संविधान का पार्ट है, उस लॉजिक से हर कोई लिबरल है. In a sense, if that is the definition of liberal, as it is supposed to be the definition of, that you want these liberties, you're liberal. But unfortunately, for those who decide who the liberal is, that definition becomes skewed. You don't actually care about freedoms. You don't care about someone having the right to voice an opinion which does not match yours. And that's the point, or the so-called self-proclaimed liberals of the world. Choose not to be liberals anymore. They choose to be ideologues for a particular ideology. So the idea is that you can make a statement on a certain end of the political spectrum, and that is freedom of speech. You make a statement to the contrary, and that's not freedom of speech. Who gets to decide that? Certainly not universities. Do they? Oh no. Well, it shouldn't be, because universities are not arbiters of what is freedom of speech. And like I said, everyone should have it. The point is, who do you recognize freedom of speech for? The problem with so-called liberals, I'll say this very openly, I consider myself a liberal in the original classical sense. Freedom of speech, freedom of body, freedom of movement, freedom of business. Which communist recognizes freedom of business? How is communism the same as liberalism? There's a difference. The classical liberal of the last 100 years or last 15, 20 years even is today become a fascist by those standards, deemed to be fascist. But the idea here is that liberalism is that, all right, I have my freedoms, you have your freedoms. That's about it. But is that the problem that's being faced here? Maybe. Let's see. Right. So what is it that I'm focusing on now? Does Ashoka University genuinely uphold the principles of open inquiry, diverse viewpoints, and critical debate? Or is its academic environment shaped by reinforcing ideological agenda? Are students encouraged to think freely? Or are they steered towards a particular worldview disguised as a liberal education? And that's why I'm going to tie this up with, the founder saying something. One of the founders writing a letter. He says that, liberalism has got nothing, or a liberal education has got nothing to do with activism. So the problem then becomes activism. It's not liberal. And there's liberal education, not liberal in the classical sense. Liberal education, any which ways, listen, something that is not the professional courses or something that is not the hard sciences. Which gets me to the next aspect that I'll be dealing with. Is that okay? Is there a culture of ideological homogeneity? Or is there a culture of intellectual diversity? The idea of intellectual diversity is that you don't live in an echo chamber. That's the whole idea. Because the premise on that is that when there are different ideas, we can reach a better idea. Goes back to the papacy when they decide as to whether or not someone is to be anointed a saint. There is one particular individual, a cardinal, who's appointed to argue against the conferment of that sainthood. And that was the person who was originally called the devil's advocate, arguing for the sake of arguing. Right? The whole idea of there being a genuine discussion or genuine debate is that, listen, you told the other side. Unfortunately, that doesn't seem to be the case. Right? Are dissenting views stifled at the university? I'm not talking about statements made by professors of the university, former or current. Are students at the university permitted, I would say so, permitted to have worldviews which don't subscribe to what the professors want to teach? The answer is an absolute no. So there's no pursuit of knowledge per se. I'm sure there is in some corners. There's some professor doing an exceptionally brilliant job. But where there is an ideological angle, obviously when you're teaching security, when you're teaching something like hard economics, when there's mathematics, it's very difficult to say, okay, I'm going to bring in ideology here. But it's the other fields where you have a larger scope for it. Or you remove things from the curriculum, or you add it, or you present it in a certain manner, where it becomes an ideological agenda that drives that, which leads to a so-called echo chamber, right? But this last aspect I'm also going to cover with before I get to, right? Whether or not it's driven by an ideological agenda is a separate question altogether. Right? But the point that I want to raise in relation to this, I'm not going to focus too much on this ideology because you're entitled. Okay, the private money going in, ideology shaped only on one side of the political aisle, determined to meet certain ends. Be that as it may, that's not a concern here. That's not the question that I'm raising. I'm raising something else, something which is more a question of optics, something that doesn't meet the eye very often. Is this? Was Ashoka University's creation driven by idealism or image building? And why have founders who were once vocal advocates of the case for Ashoka, and now why are they now distancing themselves from the university? And in that regard, how much of a headache has Ashoka become for its founders? Now, this reference of a headache is with reference to a particular letter that's been written by Mr. Sanjeev Bikhchandani, right? So again, the letter as is available in the public news channels or news websites there's a lot of advertisement there, so try to avoid it. This is fair comment on whatever, like fair use of whatever edict has published. Edict is Ashoka's University independent newspaper, if I may. I've tried to increase the size as much as I could. I don't know to what extent this is here. I think there's no point because the font is too small. But effectively, what Mr. Bikhchandani says is that he's fed up in the sense that there's some response from a former alumni who said, "Listen, boss, you set up a private university today. You don't stand up with these guys. You don't stand up for the liberal cause." And he says, "Listen, there's a difference between activism and liberalism." And why does this come about? Why does this change? Anyone who's that intelligent, and let's give credit where due, all of those founders are damn intelligent people. Right? I think anyone with a newspaper knows these people are extremely intelligent. You know very well that these individuals that you hire to perform functions, both administrative and educational, to teach and to run the university, come from a certain mindset. You do your channel, you do your due diligence, so to say. You try to meet these people, you talk to these people, you know these people. It's not like you oppose it. It's not like you oppose the activism at all. Because you certainly don't oppose liberalism. So three aspects. One is activism. The second is liberalism per se. And then there is obviously a liberal education, which is something entirely different. The fourth aspect can be, something which is purported to be liberalism, but is actually just an ideological position, which is perpetuated, which is also well within your rights. The private university, private teacher doing whatever, regulated, as long as you're not violating the law. The question then arises where not the law is particularly violated or where it isn't. But the idea is that you're always aware. It's been decades. It's been a decade. Now it hurts. The problem is, and again, this is public domain, there are founders of Ashoka University who face the flak. I'm not saying that is because they are founders. I'm sure there is an element, there is a school of thought of people who say, oh, this is because they're founders, university is very liberal, that's why these people are facing the flak. They would face the flak if something's gone wrong. No? Besides the point, if it is indeed the case that they are facing flak because of that, then hence the concern for founders who are now distancing themselves from the university. It's a cross to heavy to bear. Like I said, these are intelligent people who now realize that this is not what we wanted it to be. And that is why the question that is to be raised at this stage is, why is the branding changing? So when Ashoka University started, the founders were very clear that there would be such independence that no matter how much money someone is donating, there will be no center named after them. There will be no university named after them. The Ashoka University founders XYZ billionaire. But as they progressed over the years, again, this is public domain, you can look at the website. One particular school of economics, biomedicine, political, different schools, different departments are named after the billionaires who've given money to that institution. Plain and simple. So that's the first deviation away from what Ashoka was purportedly meant to be. There is somewhere founders don't have a name attached to the university. That's changed entirely. Thousands of things in the university are named after one founder or another. Nothing wrong with it either. I'm just saying this is how the branding is being changed. Ashoka University was driven with the idea that this will be a liberal arts university. If you want to study the hard sciences, it's not the place. We're not looking at professional education. All of that was there. Today, the university is being marketed as what? A liberal arts and sciences university. And why is that the case? Why is it that the vice chancellors, the administrators, and the faculty at the top of the administrative hierarchy in the institution are now people from the hard sciences? Physics, chemistry. I don't need to say all this. You can go look up the websites, look up Wikipedia, look up the basic stuff online. Why is it no longer people from the humanities? Because you wish to now present a narrative that this is a liberal arts and sciences university. You no longer wish to say this is the Ivy League in India. But more than anything else, the Ivy League is known for, sport. And Ashoka University was never marketed as a place which is going to be, top of the game in sport. But again, not a concern. Even if it is, even if Ivy is not sport, even if Ashoka is sport, that Ivy League marketing has been done away with. Why? Because that presents an idea of something being absolutely foreign. At the same time, it is a deliberate idea. It is a deliberate intent on the part of the founders, the administrators, etc., to try to redefine what the Ashoka University is. It mustn't be so-called. It mustn't be seen as a far left institution looking at taking up a stance against a right of center or conservative government. So it's not a question of whether or not people want to take that stance or not. The question is that is it not merely a matter of convenience? Who knows? Like I said, people who are far more intelligent than I am. But one thing is certain, that the founders and the administration at Ashoka, to whatever extent the founders are involved, because they claim that, listen, we're not involved, we maintain a distance, administrators run it, very well. But they're still suggesting, or the administration, if you don't include the founders, is that it is supposed to be liberal arts, right? And it's now supposed to be liberal arts and sciences. Nothing wrong with either, but this is the intent, because you don't wish to come across as a private, for the lack of a better phrase. I have no skin in the game who are JNU, but you don't want to be a private JNU source. The idea is you don't want to be a private, and I'm not saying JNU is a far left institution or anything. Be that as it may, not our concern. Not here, not for this moment. But you don't want to be seen as being a drug using, tax evading, or liberal left-wing so-called. I don't want to use the word term liberal. It's the original sense of the term, much like, how secular as a word has been corrupted. Similarly, liberal as a word has been extensively corrupted by people who've used it to suit their ends. So that part of the university is certainly not there, in the sense that it's never been a liberal university. It's been driven by an ideological agenda of people at the helm. And I'm saying let's keep the founders out of it. Right? Today it hurts them. It hurts them, okay, maybe not in a business sense. Maybe it doesn't. But merely the association of it. Right? Parents will, raise a child. They go on to do a lot of things. They say, okay, I disown the child. But it's never going to change the fact that the parent is still the parent. And that's what they want the disassociation from. Right? That is, I think, primarily covers what we have, because I'm on the 1 hour 30-minute mark. We primarily covered the broad topics that we wanted to cover. Broadly speaking, creation of university, non-est, sub lato fundamento. Right? When the creation is wrong, everything goes away. They're driven by a certain ideological agenda, be that as it may. The founders have a certain posturing, and the posturing is entirely for the fact that you don't want to be associated with something which is otherwise so out of the Overton window. And that's the problem. The problem is that no one actually wants to disassociate themselves from someone who's a genuine liberal. The problem is perhaps that there is no genuine liberal there anymore. Right? Maybe the idea is that things are so far out of the Overton window, so far out of the permissible point of discourse. And while you entertain thought, yes, you entertain speech, yes, but maybe they also realize that they don't want to be associated with the kind of thought that Ashoka University, which they now claim represents, but in their eyes it was never supposed to. Well, that conversation can always go on. I have lots of different comments. Someone says appoint a receiver, run and investigate this. Someone says appoint a special officer by the government. All of that. This is not the intent here. This is absolutely not the motivation behind this. The idea was that we had queries regarding, primarily the establishment in terms of the legality of it. That's something that I thought would be interesting to discuss, and that's what we've ended up doing today. Thank you so much, everyone. Thank you so much for joining us at the IYA. It's been an absolute pleasure, and we hope that we'll come back to you very soon. And this video should be up online, so you should be able to see it on our YouTube channel. And I've never said this, I don't say this very often, but like, share, subscribe, all of those things, right? And please do write to us. Please write to us for the simple reason that we want to create intelligent and interesting content. And we wish to do it with not the intent of, reaching larger audiences, but with the fact that there is such a dearth for it. The whole idea of the agenda by the IYA has been that, there are thousands of podcasts, people saying all sorts of nonsense. There's no rigor. There is no, connect with reality. That has been our intent, that there should be rigor. There should be some connect with reality. I'm not even saying everything has to be legal. I'm not saying everything has to be economic per se. Well, we're always willing to do, discussions on history, on strategy, on Indian political history. And for that, we look forward to suggestions on your end. Please do write to us. And the IYA does turn 13 in the next 10 days. So at least I wish to maybe have one more podcast in the near future. And all of you would be welcome to join us once again. Thank you so much for being a brilliant audience and sticking with me throughout. Good night. I want to do it the way Big B does it. Good night, Shabak Khair, and please take good care of yourselves. Right? This is Aju, over and out.